हॅलो, नमस्कार. आजच्या 20व्या वेबिनार मध्ये नाशिक बार असोसिएशनच्या वतीने मी आपलं या ठिकाणी सर्वांचं सहर्ष स्वागत करतो. आणि या वेबिनारच्या सुरुवात करण्यापूर्वी प्रमुख पाहुणे जे आजचे व्याख्याते आहेत त्यांचं स्वागत आणि परिचय करून देण्यासाठी मी आमंत्रित करतो नाशिक बारचे खजिनदार संजयजी गीते साहेब.
नमस्कार. हॅलो,
हा बोला.
आवाज येतो का शरदराव?
हो, बोल.
नमस्कार.
बोला सर.
ओके ओके. नाशिक बार असोसिएशन नाशिक बार असोसिएशनच्या वतीने लॉकडाऊनच्या कालावधीमध्ये आपण जी ही वेबिनार सिरीज सुरू केलेली आहे त्या वेबिनार सिरीजच्या 20व्या लेक्चर मध्ये मी प्रथमतः आपल्या सर्व वकील वर्गाचं स्वागत करतो. आज आपल्याला लेक्चर साठी माननीय जिल्हा न्यायाधीश विवेकजी गव्हाणे साहेब हे आपल्याला लाभलेले आहेत, वक्ते म्हणून लाभलेले आहेत. ते आज आपल्याला ऍडमिसिबिलिटी अँड एक्झिबिशन ऑफ डॉक्युमेंट्स या विषयावर मार्गदर्शन करणार आहेत.
हे तर रिटायर झाले पण नाही आमच्याकडे.
गव्हाणे सर हे नाशिक जिल्हा न्यायालयातील सिनियर ऍडव्होकेट BN गव्हाणे साहेब यांचे चिरंजीव आहेत. ते मूळचे इगतपुरी तालुक्यातील रहिवासी आहेत. माननीय जिल्हा न्यायाधीश गव्हाणे साहेब यांनी 2-3 रेल्वे शिक्षण पूर्ण आणि लगेच 2004 मध्ये त्यांनी ज्युडिशियरी मध्ये JMFC या पदावर कार्यरत झाले. तेव्हापासून 2004 ते 2020 पर्यंतचा त्यांचा JMFC ते जिल्हा न्यायाधीश हा प्रवास निश्चितच आपल्या सर्वांना प्रेरणादायी आणि मार्गदर्शक असा आहे. आज मितीस जिल्हा न्यायाधीश गव्हाणे साहेब हे रजिस्ट्रार ऑफ महाराष्ट्र नॅशनल लॉ युनिव्हर्सिटी या पदावर कार्यरत आहेत. त्यांच्या 15 वर्षाच्या ज्युडिशियरीच्या कालावधीमध्ये त्यांनी विविध न्यायालयांमध्ये न्यायदानाचं काम केलेलं आहे. या पदावर कार्यरत असताना त्यांनी विविध ठिकाणी आपल्या कार्याचा आपल्या न्यायदानाचा ठसा उमटवलेला आहे. सरांचं मी या वेबिनार लेक्चर सिरीज मध्ये मनपूर्वक स्वागत करतो. गव्हाणे सरांच्या ज्युडिशियरी मधील अनुभवाचा आणि ज्ञानाचा आपल्याला आपल्या प्रॅक्टिस मध्ये आणि या लेक्चरद्वारे निश्चितच फायदा होईल अशी मला खात्री व विश्वास आहे. माननीय गव्हाणे सरांनी आपलं ऍडमिसिबिलिटी अँड एक्झिबिशन ऑफ डॉक्युमेंट्स या विषयावर लेक्चर सुरू करावं अशी मी त्यांना विनंती करतो. धन्यवाद.
Thank you for the wonderful introduction and good evening all dear friends. I hope you all are doing well and accustomed to this new lifestyle post COVID-19. Friends, the topic that has been assigned to me today is a legal concept which we have been practicing almost in our everyday in the course of law. The subjects are so regular and so basic actually that whenever we get free time and we read books, bare acts to revise, we often tend to skip these provisions of law because firstly, as I said, that these provisions are in our day-to-day use, and those who pay attention to these aspects of law often tend to focus on the updates and the case laws. The number of case laws that are reported these days is so huge, and in the race of updating ourselves on those topics, we tend to lose our grip over the basics of that topic and the basic concept. So what we are going to do here today is we are going to visit the basics since most of our participants, I've been told, are very young lawyers, and of course they must have been watching lawyers indulging in heated dialogues with their counterparts. They must be watching lawyers sometimes having disagreement with the judges over these issues. So, especially for them, we would visit these concepts at a very basic level. Our focus would be to address the issues that arise during exhibition and admissibility of documents, and from the point of view of lawyers. So, when we think of proving or tendering a document in evidence, the first thing that comes to our mind is obviously whether the judge is going to accept it, whether the judge is going to rely on this. Am I allowed to present this document in the fashion it is? And so on. So the first thing, technically speaking, is we are dealing with the admissibility of the document. Now, what is admissibility? Admissibility means the document which we are trying to present in evidence, whether that document is capable of being tendered in evidence, whether it is capable of being read in evidence by the judge, whether the judge can legally place reliance on that document and decide the issue before it, whether the judge has the authority between from section 5 to section 55 of the Indian Evidence Act. Admissibility as such is not different, but admissibility is a later stage of relevancy. When you try to prove a relevant fact, the method which you adopt, you may orally depose, and when it comes to document, you wish to submit a document to the court to prove that fact. So the document with which you try to prove that fact, so whether that document, first of all, the fact has to be relevant, and secondly, that the document which you wish to tender should be able to convince the judge that this fact would be legally admitted by way of this document. So that is basically the difference between admissibility and relevancy. Proof is again a different issue. Proof is the evidence that establishes fact. So admissibility, relevancy, proof. And there's one more aspect which we would be dealing, that is exhibition. Let's say, for example, that you wish to tender an agreement to sale in evidence, and that agreement to sale, maybe it is not registered, but you have accepted certain amount of money, you have parted with possession, you wish to tender it in evidence, and the opposite raises an objection. Now, sale deed is just an instance, it could be any other document. So when you try to tender a document in evidence and the other party raises an objection, what happens? First, the judge will either, depending upon the admissibility, accept it, or the judge will deny it. But there is one more practice which is prevalent, is marking of tentative exhibits. Now, this is where actually the problem arises. I mean, as a young lawyer, we do not know what to do because the other party has objected and the judge doesn't seem to be very favorable to us. So what the judge does, sometimes the judge will mark a tentative exhibit to the document. Of course, tentative exhibit is not illegal. Tentative exhibits are being marked. There are several decisions of Supreme Court and even of the Honorable Bombay High Court, prominent amongst which is the case of Bipin Panchal versus State of Gujarat. I'll give you the citation of this case. It is a 3-judge bench decision of Supreme Court delivered on 22nd February 2001. It has been stated in this judgment that when the judge feels that deciding the dispute of whether or not to exhibit this document or whether or not it is admissible would take a considerable time and it is likely to protract the further recording of evidence, then what the judge can do, the judge can tentatively mark it exhibit. And the court has stated that there is nothing illegal in marking tentative exhibits. Fine. Because the time has to be saved, and then after the document is marked, be taken again for the final judgment. And at that time, the court would look into the aspect in detail and decide whether or not it should be confirmed or whether the document should be discarded. Fine, the provision has been made by the case law. But can you frankly tell me, exhibits have been tentatively. At the end of the case, we actually determine that aspect before, at the time of final arguments, or maybe before that, the court again takes that issue and decides that issue. Once it is tentatively marked, it is practically left to the wisdom of the judge, and you get to know it only in his judgment. That is what happens most of the times. Now, this is not an ideal situation which was expected. So, what? Now, what are we supposed to do? See, who would be at loss if at when you get to read the judgment and you are surprised to see that the document on which you had placed so much of reliance has actually been discarded by the judge? In case of tentative exhibit, you get to know this only in the judgment most of the times. And by the time you have discovered, you would have lost your case. Right? So, as a lawyer of the client who has got huge stakes in the matter, you would not want the fate of your matter to be dependent on such a situation. So, it is always prudence, if I may say so, that we should always insist upon the judge to decide the matter then and there. You never know later on what is going to happen. And by the time you come to know, things are gone out of your control. Say if the judge discards the document which you are trying to tender, if he refuses to give exhibit and passes an order, at least you know that now you will have to find some other way of proving that thing. Now you will have to find some other document, or maybe you will have to call a witness to prove that thing, or maybe you can approach the higher court. But this opportunity is lost because of the tentative exhibition. So one must always humbly request the judge, सर ते सर्व ठीक आहे, पण कृपया हा विषय जर इथेच तुम्ही याला जर निर्णय दिला तर बरं होईल. So you can always humbly request the judge. The Supreme Court in several cases, out of which I am going to quote 2 cases, has dealt with the same aspect and has stated in the case of H. Siddiqui versus Ramalingam, 2015 into bracket 5, SCR 587, the Honorable Apex Court has held that the question of admissibility is to be decided before exhibition. So you have to decide it before the exhibition. Similarly, in the case of Shalimar Chemicals versus Surendra Oil, the decision is of 27th August 2010, again of Supreme Court. The court has stated that when it comes to admissibility, don't keep the matter hanging. Decide it once and for all, and if the party which proposes to tender the evidence gets a decision which is against that party can explore the avenues of trying to prove it by some other way. So this was about the admissibility of documents. I'm sure in the process of recording evidence, almost every one of us must have at some point of time heard it from the opposite lawyer that साहेब तुम्ही हा साक्षीदार झाला याला एक्झिबिट देताय परंतु एक्झिबिट देता येणार नाही कारण की हा डॉक्युमेंट प्रूव्ह कुठे झालाय अजून राईट if the plaintiff relies on a document or the witness produces a document, he refers that document to in his testimony, and after that the judge tries to exhibit it. Maybe the witness has signed the document, but the witnesses are yet to be called. So in such cases, it is very often that the opposite party would raise an objection. साहेब अजून प्रूव्ह झालेला नाहीये, प्रूव्ह झाल्यावर नंतर एक्झिबिट देऊ. Very hotly contested. I mean, the seniors who are on this webinar would agree to it that many a times a heated conversation or heated dialogue takes place not only between the two advocates, but even between the judge and the lawyer. So you would not want to get into such a situation. But then, when they say that the document has not been proved and therefore it cannot be marked as exhibit, what could be the analogy? I mean, see, I have not come across any provision or any procedure which lays down a stage at which the court is supposed to acknowledge or declare the number of, or the list of documents which are proved. Admissibility is one thing, proof is altogether different. So there is no stage or there is no provision whereby the judge, before delivering the judgment, tells the parties that, look, these are the 4 documents which have been proved, and therefore now I'm going to deliver my judgment based on these documents. No, the judge will never do it, and there's no provision. And if during the course of discussion the judge happens to give even a slightest indication that the document has been proved, and वकील साहेब पुढचा साक्षीदार कशाला घेताय, प्रूव्ह झाले ना, if the I mean, the party can even refuse to conduct that matter before the judge, saying that the judge has already formed his opinion. So as a matter of practice, there is no provision, no procedure where the judge will recognize a particular document as true. Yes, of course, as a lawyer, you may claim that a document has been proved. You can always say that such document has been proved and therefore my case stands on a better footing than that of the defense. You can even use the term proved during the course of recording evidence when you wish to adduce further evidence. I mean, you are lawyers and you have all that freedom to do it. But then, ideally, proof is the declaring or saying that a particular document has been proved is the sole prerogative of the judge, and he can do it only in the judgment, not before that. Judge cannot say before judgment that a particular document has been proved, because let us see the definition of proved, then we'll get back to it again. Proved has been defined as a fact is said to be proved when, after considering the matters before it, the court either believes it to exist or considers its existence so probable, and so on. So after considering the matters before it, here, though we are not talking about fact, but we are talking about proof of document for the purpose of exhibition. So after considering the matters before it means that the judge will have to take into consideration the cross-examination of the witness through whom the opposite party is trying to prove that document. So the cross-examination may discard the credibility of that document. Or it may happen that after that witness is over, some other witness is called, and that witness throws light on that document. And on the basis of the testimony of the other witness also, maybe the judge will refuse to rely on that document. So before the judge could say that the document is proved, the judge will have to assess the material on record, which could be in the form of evidence, that document itself, or some other document which tends to disprove this document. And this can only be done after the entire evidence is available before the judge. Let me give you an example. Why proof should not be associated with exhibits. Of course, there are case laws. We will be discussing those case laws, but we will come to know from this example what is the analogy. Say you're dealing with a case of prohibition, 66(1)(b), or I believe now that sections might have changed, because in past 10-12 years I have not dealt with those matters. But then the first witness called in the court by the prosecution is the attesting witness of the seizure memorandum. The attesting witness is shown the memorandum by the PP. Memorandum is Panchanama. So the PP asks the witness, have you signed it? The witness says yes, it bears my signature. Then the PP asks further questions relating to that memorandum, and the witness says no. He says, साहेब मी सही तर केली आहे, माझ्या घरी पोलीस आले होते, त्यांनी मला सांगितलं की तुमची जी 15-20 दिवसापूर्वी जी सायकल चोरीला गेली होती त्या संदर्भात हा काहीतरी कागद आहे, सही करून टाका, म्हणून मी सही केली. पण मी कुठेही गेलो नाही, माझ्या समोर कुठल्याही प्रकारची जप्ती झाली नाही, पण सही मात्र माझी आहे. And then the witness steps down the witness box. Now the question before you is whether you would exhibit this document. Because if proof had to be related with exhibition, then at this stage at least it doesn't seem to be proved. The second witness has not been called, even the IO is yet to be examined. And let's take a further step. And the prosecution does not call any witness for a long time, and ultimately the evidence is closed, and the judge is to deliver judgment of this case, wherein that attesting witness is the sole witness. There's no other witness. Now what? Obviously, howsoever small the judgment of the court may be, but that judgment would be all about that memorandum and the witness who said that his sign is there on the memorandum, but he has not seen the seizure of the articles. So, in order to be able to discuss that memorandum in his judgment, the document must have been exhibited. So, see here, the document most certainly is not proved. There's no question of proof. The judge will never rely on such a document. But then it still had to be exhibited, because otherwise the judge won't be able to discuss it in evidence. And it was actually shown to the witness in the witness box. The witness identified it. It means that it was admitted in evidence. So when a document is already admitted in evidence, when it is shown to the witness box, and when it is not discarded by the judge as inadmissible, then it has to be exhibited. We should not wait for proof, because see, proof, all the ingredients which are required to prove that document will be accumulated. They will be formed at a later stage, when both the witnesses, suppose first witness turned hostile and the second witness is called and he supports, then the IO is called and the IO tells everything about the memorandum. So all these stages will have to be completed. Only then the ingredients maybe would be available before the judge, and then maybe the judge would be in a position to say that it has been proved, not before that. So the point I'm trying to make over here is that the proof may be later, but the process of proving has already started. And how has it started? It has started by way of the first witness. Now, if exhibition was so immaterial, then why is it given in the first place, right? Young lawyers may question that, sir, then what is the need of exhibition? If proof does not, exhibition doesn't amount to proof, then why to give it? And if tentative exhibits can be given without even ensuring whether the document is admissible or not, what is the significance of exhibition? But the exhibition still is very, very significant. It has been stated in judgments that it is an administrative act. By way of exhibition, you can locate where the document is. Yes, that is very true. But apart from that, important aspect of exhibition is that it is an indication to the parties that, look, I am going to discuss this matter in my judgment. I am going to rely, whether I ultimately rely or not is a different thing, but I will take this document into consideration while deciding this matter. And that is why exhibition is given. Suppose if the practice of exhibition was not there, what would have happened? Someday, when you get judgment of the case and that judgment has gone against you, you would go to the court and tell the court, maybe appellate court, you would go to the court and tell the court that, sir, I was unaware that the document which I had relied was going to be discarded by the judge. The judge did not even read my document in evidence. Now, where do I go? So, tomorrow you should not go to the court and say that I was unaware whether this document formed a part of the evidence or not. Right? Tomorrow you should not go and complain. This exhibition assumes significance and importance. So beyond indication as to the admitted documents, it plays an administrative role also. There's one more aspect when it comes to exhibition, and it would be unfair on my part if I do not touch it. Most of us must have experienced that sometimes when you try to tender a document in evidence, and maybe that document is either a Xerox copy or for some other reason, the judge is not convinced about its admissibility. And the opposite party says that, sir, asa kara, yala exhibit deta yenar nahi, far the far article deun taka kai harkat nahi. The other side lawyer very graciously does that favor on you. What he is actually doing is that he is making sure that the document does not get exhibited. And you get satisfied by that article. Right? It must have happened, and you must have noticed this, because I have seen so many matters wherein PPs or some lawyers, they insist upon the judge to mark articles to documents. Now, I have never seen any degree of evidentiary value in this manner, that if suppose a document has a very high evidential value or it has a high degree of admissibility, then you can mark it exhibit. And if it has got a low level of admissibility, then you can mark it article. No, there's nothing like that. If a document is admissible, it is admissible. If it is not admissible, it is not admissible, even if you mark it article or you mark it exhibit. It is not going to change the legal status of that document. There can't be a senior KG and junior KG kind of thing, like senior or more admissibility, so exhibit, and less the admissibility is articles. It's not like that. I'll give you an example how and why it is not like that, because there's a Supreme Court decision which I'll be referring in the later part. it would be very easy to understand what is an article and why document should not be marked article. Say, I have a piece of paper over here, and there's one person sitting besides me who has caused a huge loss to me, and I intend to kill him. What I do, I scramble this paper. I scramble this paper and forcibly push it inside his mouth. I push it so hard that he ultimately strangulates and dies. He succumbs. The victim dies. Now what the police do, they will take the dead body and then they will remove this piece of paper from the dead body. And this piece of paper is in front of you. There may be a poem written on it, or maybe it's a blank paper, or maybe there's some other content, relevant or irrelevant. What would you do? Should this be marked as article because it is a paper, it's a document, there's something written on it? It is a weapon of this offense. Using this paper, someone has been choked to death. So it will always be an article and not a document, even though it may be paper, even though there may be content on it, which is irrelevant. But it will continue to be a article. Vice versa. A is a businessman who is kidnapped by his rival, say Arvind. Now Arvind kidnaps A and confines him. Kidnaps means abducts, not kidnap. It would be out of the country. So Arvind abducts A and confines him in a very small room where there is absolutely nothing. Except a window, there's absolutely nothing. After 5-6 days, this A, he somehow manages to break a piece of the tile, flooring tile. A sharp piece of that tile is broken. He uses it to scratch that tile and writes the name of Arvind on that tile. He scratches and he scribes that Arvind kidnapped me. And after 2-3 days, in that confinement, he dies. Now the investigating officer, obviously he will remove that tile and produce it before the court for the sake of evidence. Now whether this tile is an article or a document, I mean whether it is an article, it should be marked article, or whether it should be marked an exhibit. Admissible to hai, it is admissible. Let us see the definition of document. Document means any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those means intended to be used or which may be used for the purpose of recording that matter. Described upon any substance by any means. So here, this piece of tile is a document on which the victim has stated the name of the person who kidnapped him and maybe who is responsible for his death. So despite being a tile, it is a document, and that piece of paper is an article. So this is the example I believe we should always remember whenever we are confused during the process of recording evidence, and whenever somebody suggests that let us mark this document as an article. There is a decision of the Apex Court on this point. The Apex Court, in the case of Bhupesh, son of Vittal Rao versus State of Maharashtra, decided on 5th June 2018, observed that many cases that go even to the Supreme Court contain documents or record which has probative value but which is not marked exhibit, and instead they are marked articles. In this case, what had happened is that the evidence which had probative value was in the form of a hard disk, and that hard disk, the material that was contained in that hard disk was not marked as exhibit, but it was given an article. So the Supreme Court had to say that even though it looks like a hard article, but the contents, and for the purpose of that contents, you should have marked it an exhibit and not an article. Speaking about filing documents in the court is just a suggestion. I would always suggest my friends that whenever you have a very, very valuable document, and if the court in which you are going to file is a heavily burdened court, try to avoid filing that original in the beginning only. You can produce it, request the court to get it checked from the AS, keep a verified copy on record, and take that original back with you. You can always produce it before the court for inspection whenever the evidence of the witnesses is being recorded. In CPC, there is provision, and also in criminal cases, this can be done. So it is a rule of precaution. If you adhere to it, the better. When it comes to admissibility, the custody assumes a great importance. If that document comes from a proper custody, it becomes very easy for the court to admit that document in evidence. And for that reason, the Evidence Act has even given presumptive value to certain documents. For example, we know that Section 90 provides for presumption for a document which is 30 years old, which has been produced from a proper custody, and then there's presumption that if it bears the signatures and other contents, then that signature has been affixed by the person by whom it is purported to have been signed. Similarly, in case of electronic record, there's presumption that if the electronic record comes from a proper custody, then if it is digitally signed, then that digital signature is of the same person by which it purports to have been signed. So this presumptive value has been given for proper custody. But it is not so always. What if I tell you that a document which has been stolen is also admissible in evidence? Because see, since proper custody has importance, then by that analogy, a document which is stolen should never be admitted in evidence. It happens, I mean, in US courts, they never admit such documents. If it is procured in an illegal manner, you can't admit it in evidence. But here in India, fortunately or unfortunately, it is not so. The Supreme Court, in the case of R.M. Malkani, AIR 1973, Supreme Court, page number 157, has stated that even if a document has been procured in an illegal manner or even by way of theft, it is still admissible in evidence. Of course, the person who procures it in an illegal manner will have to face the litigation or the consequences of that illegal possession. The person will have to face those charges. But then, in a civil matter or in some other case where that theft or illegal procurement is not in question, it can be admitted in evidence. See how this can change the scenario. If I have a property which is worth crores of rupees, say 5 crore rupees worth property is there, and I have comparatively a better title over that property than the defendant, but the document with which I will be able to prove my better title, that document lies with the defendant. It could be any document. It could be a document showing the payment or any other document. So what I do, I know that if I steal it, I will have to go to jail under section 379. But I still take that risk and I steal it from the defendant. Odds as against a theft. I mean, what are the odds of conviction? And even if I get convicted, what would be the length of my imprisonment? So a person may even construe this provision to profit himself in an illegal manner. It would be really unfair if we speak about admissibility as well as exhibition and we don't touch the electronic documents. After the enactment of Information and Technology Act 2000, there have been lots of changes in various laws, particularly the Evidence Act, IPC, CRPC. What this act did, it gave legal recognition to electronic record. It not only gave legal recognition, but it, because of these amendments, now an electronic record is treated at par with a document. It is regarded as a document, like any other normal document. Only the way of proving, the way of admitting that document in evidence is slightly different. But then it is regarded as any other normal document. So, with respect to admissibility, as we all must be aware of section 65, particularly 65B, because there are so many cases on that provision, and that provision is the most talked about provision when it comes to discussing electronic evidence. That provision says, now firstly, this section 65 and 65B, as stated in Anwar versus Bashir, this is a parallel code. This acts as a parallel code and it is a complete code in itself. And therefore, when you think of proving or adducing an electronic document in evidence, you don't have to look into the traditional document related sections like section 63, 65, and so on. Section 65 and 65A and 65B take care of the entire admissibility issue. With respect to this admissibility, 3 judgments were of pertinence. First was the case of Navjot Sandhu, which is also which is related to Parliament attack, which stated that 65B certificate is not necessary. But then the case of Anwar versus Bashir came. It stated that no, if the document is secondary evidence, if it is not the original, you have to produce 65B. Without 65B, you cannot produce secondary evidence, or else you will have to produce the original before the court. So 65B was made mandatory. Thereafter, there were several other case laws, but significant amongst which is the recent case laws. It's not recent, it was in 2018. It is the case of Muhammad Shafi versus state of Himachal Pradesh. The significance of Muhammad Shafi is that it says that if you are not the author of the electronic record, or if you do not have the original electronic record, but you have a secondary copy, then you can still produce it in evidence, and the requirement of 65B certificate won't be applicable in your case. Now, in order to understand the significance of this case, let us take an example. A school girl who is a teenager is allured by some person, taken to his room, where she is ravished or even raped. And while doing so, the person, the accused, he even records that entire scene in his mobile phone. After this act is over, that girl is, of course, she is, they are known to each other, friends or maybe in relationship. And after this act is over, one day, while surfing through his mobile, the girl comes across the clip in her boyfriend's or that man's